it must be admitted that a man born on this soil of alien parents enjoys a dual nationality and owes a double allegiance. A child born under these conditions has a right to elect what nationality he will enjoy, and to which of the two conflicting claims of governmental allegiance he will pay obedience. Now if, by any possible construction, a person at the instant of birth, and for any period of time thereafter, owes, or may owe, allegiance to any sovereign but the United States, he is not a natural-born citizen of the United States. If his sole duty is not to the United States government, to the exclusion of all other governments, then he is not a natural-born citizen of the United States. The doctrines of dual citizenship and of double allegiance are too well known, and too well founded in international law, to be doubted or disputed. The doctrine of election necessarily implies the existence of a double allegiance. This condition naturally arises where a person is born in one country to a father who is a citizen of another country. By rules of municipal law, which generally prevail, such a person has citizenships by birth. 1. Citizenship by virtue of the place of birth, jus soli, and 2. Citizenship by right of blood, jus sanguinis, i.e., by virtue of the father's nationality. Unless this be so, the child on attaining his majority has nothing to elect. More International Law Digest. 3. 524-525. The subject of double allegiance and dual citizenship is a well-recognized doctrine of international law, and one with which all nations have to deal. The question has been presented many times, and in many different ways, to the government of the United States. That it has taken official cognizance of the existence of double allegiance is not only not questioned, but is too well known to need references. It may, however, be elucidated by citing a few of the instances. An application was made for a passport for a youth of 17, whose father desired to send him to Germany as a student. Mr. Flingewisen, then Secretary of State, in regard to him, wrote the following. The young man referred to, under the Constitution of the United States, having been born in this country, is while subject to the jurisdiction of the United States, a citizen of the United States, notwithstanding the fact of his father being an alien. As such citizen, he is entitled to a passport. This, of course, would be a sufficient protection to him in every other country but that of his father's origin, Germany. There, of course, as the son of a German subject, it may be claimed that he is subject to German military law, and that, not being then subject to the jurisdiction of the United States, he cannot claim the rights secured to him. More International Law Digest. 3. 532. That young man had a divided allegiance. A double allegiance necessarily implies a divided allegiance. His allegiance is not exclusively to one country or to one flag, and a man born with a double allegiance cannot be a natural-born American. Again, Mr. Gresham, Secretary of State, held that, while a person born in the United States, though of alien parents, is by the laws thereof a citizen, yet, should he be taken, by his parents, while a minor, to the country of which they are subjects, he becomes amenable to the laws of that country, and subject to a claim of allegiance thereunder, jus sanguinis. On this ground, the Department of State refused to issue a passport for the protection of a minor born in the United States, whose parents proposed to return with him, for a brief period, to the country, Russia, of which they were subjects. How could the government of the United States refuse the issuance of a passport to a natural-born citizen under those circumstances? That child was not considered a natural-born citizen of this country, and yet his parents proposed to return with him to the country from which they had emigrated, only for a brief period.